Hey everyone, Harry here to talk about a few orders from the Supreme Court today. Now, these are the kinds of orders I typically never even mention. You'll often see on a Monday a whole flurry of reports in the major media. Supreme Court denies this claim. Supreme Court rejects that case, etc. And what they're really referring to is the Supreme Court declining to take a case. Their review in almost all instances is discretionary. That's what that cert petition or petition for certiorari refers to. They decide to take a case. When they decide or decline not to take a case, as they do in 98% of their cases, there's no precedent there. They haven't done anything. They haven't considered it. So it really is typically misleading when you hear these reports of what the court did. And again, as I say, often on days, and Monday is typical when they release a lot of orders. Nevertheless, there are two cases they did that with, and they've been prominent cases that people have been following. So they are worth noting just because it shows those cases are done. They're at the end of the line. They won't happen anymore because the Supreme Court denied review. So the court didn't do anything on the merits, but nevertheless, by saying we're not going to take these cases, they are now dead in the water. The first one, Michael Cohen's case. You've probably been hearing about this for many years. It happens during COVID. Cohen's on home detention. He is summoned by the Bureau of Prisons and asked to sign a piece of paper saying that he will not publish his account of Trump and Trump's various misdeeds. And he says no, and he's imprisoned, and he brings a claim of retaliation after he's released, saying, you violated my First Amendment rights. And the district court said you did violate his First Amendment rights. And it sure looks, if the facts are as he said, that it was both, really kind of crass and ham-handed. And so one of the many things you think about, should Trump win in 2 weeks, that this is how justice would be dispensed to his enemies, and a violation of his First Amendment rights. So what's the problem? Because he loses. He sued under what's called a Bivens claim from the case in which it was recognized. And that claim arises, the court decided in a sort of high water liberal decision that the Constitution itself provides a remedy for money damages, that it's just not really feasible. You can't be made whole even remotely typically by doing what? If you're arrested, you can make a claim they violated my Fourth Amendment rights, so you don't get the evidence. But where do you go for compensation for your actual deprivation of rights? And the court found a Bivens remedy, and it proceeded to recognize it for violations of 3 different constitutional rights under the First Amendment, the Fourth Amendment, and Eighth Amendment. But then began a long period of retrenchment that is near total. And the court in a 2022 decision basically said, we're not doing any more Bivens claims, except the very ones that have been recognized. And when it's at all different, we will not expand, is the way they put it, Bivens. And the argument is, this is for Congress to do. Congress is the one that should create causes of action. They could pass a statute saying you can sue for money damages. They haven't, so it's not for the court to do. However, the court did not actually overrule Bivens, but they've frozen it in place and made it clear they're not recognizing any new Bivens claims anytime, in the next many years. So that's what happened here. In the district court, as I told you, said, yep, this is a good Bivens claim because Cohen's First Amendment rights were violated. The Court of Appeals said, nope, it's not a good Bivens claim because you read what the Supreme Court has said recently. It's a little bit different and new, so it doesn't work. No Bivens claim. Cohen petitions for review saying, find that this is one of the new situations where you'll still breathe life into Bivens, and the court today says no. just declines review. No comment, or just says it won't do it. So that means that Cohen has no redress. And then more generally, a good thing to know is it's the so-called Bivens claims, which were implied directly from the Constitution by an earlier, more activist Supreme Court, are basically frozen in amber and not going anywhere. Even, in fact, if they find in the 2022 case, they took a pretty minor distinction and made that into, well, this looks like something new, and we don't do things new with Bivens. I don't think they'll be doing things old or new with Bivens. And Michael Cohen's case shows that that Bivens is nearly a dead letter, although they haven't overruled it. And also that Michael Cohen himself is out of luck for what seems like not just a violation of rights, but a really sort of nasty Trump-like retribution. Sign here and you can't publish about me, or we're putting you back in jail. Okay, so that's one. The second one has to do with a case that got a lot of attention because it raised the claim that so-called independent agencies should be struck down. This would be the holy grail for a lot of conservatives. Independent agencies basically are agencies where the president doesn't have unfettered discretion to fire the person in charge. That's typically what they are. And so there's a for-cause provision. And they have, for many years, chafed conservatives who believe in a unitary executive. And why would we have a agency? It's under the executive branch, supposedly. Well, then the executive has to have complete control. Where else could it come from? And it feels to them like a kind of headless fourth branch because it has these additional powers. Anyway, the court has already struck several blows against independent agencies. Remember, it overruled Chevron last year. It found that the Consumer Protection Finance Bureau was unconstitutional in its mechanism for removing the head person. And this is like what would be the breathtaking step of actually invalidating all these independent agencies. There's a very solid, or it had been thought, generations of law students have learned it, case called Humphrey's Executor, which has said these agencies are okay. And the Court of Appeals here said, this is not for us to overrule. Maybe the Supreme Court will want to do it, but if Humphrey's Executor is still on the books, then that means these are okay. The entity that brought the claim asserted standing basically on the failure of a certain agency to give them an exemption for Xerox fees. Like we're talking, pennies or not much more. And the Solicitor General came in and said, there should be a de minimis standing requirement. Technically you could learn in law school or in the bar exam, somebody's out 5 cents. Well, that's an injury. It's a pocketbook injury. But this strains that principle to the breaking point. And so find that there's no standing here. That's what the United States said with this petition. And that's a complication in this case that would have given the court good reason not to take up this claim. In other words, it's by no means that we're out of the woods and the court's doing something extremely radical and lopping off the entire set of independent agencies and requiring them to be brought under the executive branch and the head of them being able to be fired at will. That could still happen, and it would be breathtaking, a total demolition job on the administrative state as we now know it. The court passed doing it on this case, and one very strong reason is they would have had to take up a very gossamer thin, at best, standing argument. So why not wait? Any action by any of these agencies, whoever is aggrieved by it can bring a case, and they can always raise this claim. So this claim will be coming back, and probably the court will take it at some point. And we know there are some justices who are in favor of this kind of, radical reconstruction of the administrative state. So at that time, we'll all be holding our breath. Okay, so 2 non-actions by the Supreme Court, nevertheless useful to have a sense of what they are and why those 2 particular cases have come to the end of the line. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.